Hello, I'm Rachel Jones from Legal Services Vermont, and with me is George Salmons. We'd first like to thank the American College of Bankruptcy Foundation for supporting this video series. So in this second video of our series, we'll be covering the process of filing a simple Chapter 7 bankruptcy case from start to finish with a bankruptcy attorney. So on average, Chapter 7 cases take about 4 to 6 months from the moment of filing to the closure of the case. And it's often called a liquidation bankruptcy case because non-exempt assets can be sold off to pay creditors that, however, most filers end up keeping all or most of their property throughout the process. So I'll hand it off to George to ask our first question.
Great, thanks. First question is, how would I go about selecting a bankruptcy attorney?
So you first want to find somebody who has expertise in bankruptcy. In Vermont, there are several attorneys who can file Chapter 7 cases. One way to find an attorney is to contact the Vermont Bar Association's lawyer referral service. And to do this, you can call the lawyer referral service at 1-800-639-7036. And that's on Monday through Friday, 8 a.m. to 4 p.m. Also, when you first meet with a bankruptcy attorney, the attorney will want to review detailed information about your income, your assets, and your debts. If you own a home, the attorney will gather information about your home's value and the amount left on the mortgage if there is one. The attorney may also have you fill out a long questionnaire, which will likely cover your financial information and your monthly household expenses. Some attorneys may require you to bring a copy of your credit report, but of course, each attorney differs in what they require and what they want to see from the start. It is very important to keep in mind that you provide complete and honest information to your bankruptcy attorney. It's the attorney's job to review your assets and tell you if bankruptcy is the right choice. And if you are able to keep all your assets if you file. But keep in mind that only debts listed on the bankruptcy petition will actually be discharged. And also not fully disclosing your assets or providing false information to the court is a federal crime. So you always want to be honest and provide as much complete information as you can. And then also keep in mind that many people are able to keep all or most assets when they file a Chapter 7 bankruptcy because there are exemption laws. Exemptions protect certain values of assets in a bankruptcy. So for example, if you use Vermont exemptions, $125,000 of equity in property is protected in real estate. Vermont exemptions will also protect $2,500 of equity in a car or truck. And there are also exemption amounts that can be applied to miscellaneous assets. So all in all, it's best to speak with a bankruptcy attorney just to determine whether you can keep all of your assets or most if you file for a Chapter 7 bankruptcy. And then the attorney will also discuss their fees for their services, which can vary considerably from person to person and case to case. The fee for the bankruptcy attorney should be a flat fee instead of an hourly rate. But some bankruptcy cases are more complex, especially if high value assets are involved or mortgages, for example. And bankruptcy fees can depend on the complexity of the case. So if you agree to work with an attorney, the attorney will typically require you to pay a retainer fee for their services and then sign a contract to complete this agreement. And then once you've made the decision to file for Chapter 7 bankruptcy and you found an attorney, you will have to sign up for a credit counseling course. And this is required for all bankruptcy cases. And you have to complete the course within 180 days before filing the bankruptcy petition. And so a list of approved credit counseling course agencies can be found on the Vermont Bankruptcy Court's website.
Great, thanks. And just one more time, that's the best way to find the lawyer is at the Vermont Bar Association lawyer referral service, correct?
That is one way to file if you don't know attorneys' names. If there's word of mouth, if you know other people who file bankruptcy, you may have some other resources to ask. But that is a great service if you would like a list of names and you would like a referral in Vermont.
Great, thanks. And so how is the Chapter 7 bankruptcy case filed?
So the bankruptcy case is started when a petition form is filed with the court. So the petition is accompanied by a certificate showing that the filer completed that approved credit counseling course. And then several other documents are included in the filing. For example, there's a set of schedules which lists debts, assets, income, and expenses. There's a statement of financial affairs, which covers income and other financial information. There's a statement of whether you intend to keep secured property if applicable, a statement of monthly income, a means test calculation to show that you're eligible for a Chapter 7 bankruptcy, copies of pay stubs from 60 days before you file the bankruptcy case if applicable. And then there's the filing fee. And the court filing fee for Chapter 7 bankruptcy currently is $338. It is possible for this fee to be waived with the court's permission if you are very low income. It's also possible to pay the filing fee in 4 installments, but these must be paid before the bankruptcy case is completed. And if you're very low income, you should ask your bankruptcy attorney about these options. And just all in all, it's important that all information is precise and honest because it is easy to overlook certain assets like tax returns or child support arrearages. And it's also important to include all debts in the petition that you want to eliminate. Your bankruptcy attorney will likely pull your credit reports to check and make sure that all of your creditors are included. And, so it's important to know that if you owe other parties, like a friend or family member, that may not show up on a credit report, like other debts.
Great, thanks. There's a couple terms that I'm unfamiliar with, and I'd like to ask you about them. The first one is, what is an automatic stay?
Good question. So the automatic stay is a benefit provided to bankruptcy filers. So once you file bankruptcy and all of your creditors are notified, all of the creditors that are listed on your petition, all collection actions are paused. So this means that if the bankruptcy case is pending, a creditor or a debt collector can't pursue a court case, they can't garnish income, they can't seize property, or otherwise try to collect on the debt. And this also includes debt collection calls or letters that people may receive before a court case is filed. So the automatic stay, it only applies to debts that are included on your bankruptcy petition. So this is just one more reason why it's important to include all of your debts that can be discharged on the petition.
Got it, that makes sense. And then who is a bankruptcy trustee?
So the trustee is a person who oversees the bankruptcy process, and they make sure that the creditors get paid if applicable. So if there is property that is not protected in the bankruptcy case, the trustee will oversee the sale and distribution of funds. However, many Chapter 7 bankruptcy cases do not involve property sales since assets are often exempt and covered by exemption limits.
Okay, that makes sense. And then another term I see a lot is, or what is a 341 meeting or 341 meeting?
Good question. So the 341 meeting, it's also called the meeting of creditors. So after your bankruptcy case is filed, the creditors will be mailed a notice of this meeting from the bankruptcy court, and you will also receive this notice. The trustee will attend, representatives of your creditors may attend as well, and you need to attend this meeting with your attorney. So during the meeting, the trustee and any creditors who might attend may ask you about your financial information, which you will answer under oath. This meeting is mandatory, and the bankruptcy case may be dismissed if you don't attend. So it's important to know when you're notified and to keep an eye on that and attend when you're asked.
Great, thanks. And so I just want to confirm, I have to go or I have to attend the 341 meeting in person?
So currently 341 meetings in Vermont are held over Zoom, and this is since COVID, they've become remote.
Great, that makes sense. So in the state of Vermont, the 341 meetings are remote. Just want to, okay, great. What is the post-filing debtor education course that you were talking about?
Good question. So after filing bankruptcy, there is a second course that you must take called the Debtor Education course. And it's similar to the credit counseling course that you would take before filing. Like the credit counseling course, the second course is mandatory in a Chapter 7 bankruptcy. It can be taken online or over the phone, just like the credit counseling course. So it's not something that you need to take in person. And it usually takes about 1 to 2 hours to complete, depending. In some cases, you can stop and start. But again, you're completing this and getting a certificate showing that you completed this course. And then once you complete this course, you will submit proof of completion to the bankruptcy course or bankruptcy court, so that can be added to your file.
Great, thanks. So there's a course in the beginning, a creditor course, and then a post-debtor education course after.
Correct. Credit counseling and then debtor education.
Excellent, thank you. And then lastly, what is a discharge?
So getting a discharge, the aim of the bankruptcy, it means that you are no longer having an obligation to pay off debts that were included in the bankruptcy case. So since your debts are eliminated after the discharge, creditors and debt collectors will no longer be able to collect on these debts. This is permanent, and you won't receive collection calls or letters after those specific debts are discharged. So keep in mind that you will need to still make payments on secured debts, such as car payments, if you want to keep the car or other collateral. Some filers may choose to sign reaffirmation agreements with creditors. And a reaffirmation agreement, it's where the filer remains obligated on a debt after the bankruptcy case is complete. And this applies to debts that may have been discharged otherwise, but the filer and the creditor come to an agreement to have this debt keep going. And it must be approved by the bankruptcy court. And also the filer does not have to agree to reaffirm a debt if the creditor pressures them to. This may apply in situations where the filer is making payments on, say, a car loan and wants to keep the car after bankruptcy, and they are able to keep current on that debt. But at the same time, reaffirmation agreements aren't usually ideal for unsecured debts, such as credit card debts that don't have collateral, such as a car. So if you aren't sure on whether a reaffirmation agreement is a good choice, it's always best to speak with a bankruptcy attorney about your options and your individual situation. And then, of course, remember that debts that are not listed on your bankruptcy petition will not go through the discharge. There are also debts that can't be discharged anyway, such as certain domestic obligations like child support, alimony, or debts incurred by driving under the influence or fraud or embezzlement. And thank you so much for joining us in this video series. Our next video will discuss the aftermath of filing a Chapter 7 bankruptcy.